If you find out that there are issues with the property that you're looking to buy during the course of the transaction, there are a number of things that can be done to rectify issues. So if there is a problem with a right-of-way, we can take statements from the seller solicitors and get indemnity insurance, which is available for a range of title defects, so problems with the property, for a one-off fee. We can raise additional inquiries to try and clarify what's happened with the property. We can also go to the local authority and get retrospective planning consent if that's what's required, or conservation area consent if that's required. Most issues can be resolved prior to exchange of contracts. If you find that a seller has purposely misrepresented a situation prior to exchange of contracts, it might be the point at which you consider all the information that's in front of you, so that you then question everything that's been told to you. You might need to make many further inquiries and get a lot more clarity. If you have got to the point of exchange of contracts, that is when you're bound to buy the property, the legal process would become more complex, whilst we either got litigation advice on whether the contract could be rescinded, that is, overturn the contract and put everybody back to the position they were in, or whether the problem could be rectified between exchange and completion if somebody wanted to go ahead with the purchase. If you've got to the point of completion and you find out that there's been a misrepresentation, then we really do have to get litigation involvement and look at the various remedies for overturning the transaction, and that can be extremely costly. There's a legal principle, caveat emptor, which means buyer beware. Buying property, it's not governed by consumer law. The onus is on the buyer and their solicitors to make sure they've made all the inquiries that they need to make, because if they don't, you're stuck with it.